Greetings and welcome to Stay of Action from American Jurisprudence. Before we get started, to remind everyone, this is strictly for the entertainment and educational purposes of this YouTube channel, broadcast not to be used, misconstrued, or abused for anything legal, lawful, personal, private, financial, tax, business, or otherwise. So please don't do this at home. That said, this was condensed from the American Jurisprudence on action, and specifically we're covering the sections related to stay of action. So, with that said, again, let's get into what a stay of action is. So, it starts on section 66, the power of court to grant stay, generally. So, the definition: a stay is a temporary suspension of a procedure in a case until the happening of a defined contingency. A stay halts all progress of the action and preserves the status quo without addressing the merits. Some of the key characteristics of a stay: it's temporary in nature. It's a court-ordered suspension, quite different from dismissal, as we'll see, and there's no additional steps during the stay. So a stay is a suspension of the procedure. It halts all progress of the action. So let's look at some of the distinctions from the other types of procedural changes. There's a continuance, which is a postponement from one term of court to the next or later date in the same term. So it's a postponement from one date to the next. An abatement results in a complete dismissal or discontinuance of the action. So we have a continuance, an abatement, and a stay. So the practice tip is the determination of whether to issue a stay of proceedings generally rests within the court's discretion, as it is a court-ordered suspension. So it's not a dismissal, it's not an abatement, and we'll get more into about the nature of it being related with continuance. So section 66, the power of the court to grant stay, continuing here. We have some cumulative supplements. I believe this was from a 2022 supplement, so it's quite current. And here's some of the cases. This one's from District Court in Massachusetts, 2019. This is from Haiwang Yoon versus Seyoon Lee. And South Korean, stay of action brought by a South Korean citizen who was living in the United States and was allegedly involved in an embezzlement scheme against the South Korean Broadcasting Network and employees investigating the scheme. Pending resolution of action initiated in South Korea, it was warranted in action brought against the network, alleging violation of Massachusetts wiretapping statute, defamation, and libel. So the stay of action brought by the citizen against the Korean pending was warranted. So this is the stay of action was, the stay was done where? All right, so it was in against South Korean, let's see here, initiated in South Korea. So the stay was in Massachusetts. And Vermont Federation of Sportsmen's Clubs versus Birmingham. When a stay is a suspension of proceedings until a specified event occurs in another case, it is in the nature of a continuance. Interesting there. So the specified event, so it's a contingent event, but it's a stay, but it's in the nature of a continuance for whatever reason on this case, and it's from 2020, so quite current. So we're on to section 67 now, the grounds for stay, generally. The court's power to stay in action is discretionary, so this is not a mandatory action here. And the grounds for ordering a stay necessarily vary with the circumstances of each case. So the grounds will vary. When an action may be stayed: substitution of another person for a party who has died, during the pendency of the action. So you can stay it while there's a substitution of another. Exhaustion by the plaintiff of administrative remedies. And joinder of necessary parties. So necessary parties are being joined, then perhaps the action will be stayed until whatever needs to be dealt with the new parties. And exhaustion by the plaintiff of administrative remedies. Interesting one there too, but there's a caution. When a party's death does not affect the merits of a case, there is no need for strict adherence to the requirement that the proceedings be stayed pending substitution. So requirement, as we were seeing, is discretionary. The grounds vary. So let's see here how they could vary further. In cases of extraordinary public moment, oh boy, extraordinary public moment, a plaintiff may be required to submit to delay not immoderate in extent if the public welfare or convenience will be promoted. Considerations for granting a stay. There's expense and convenience. There's availability of witnesses. There's also considered the stage to which the proceedings have progressed. Different part of the proceedings, then the stay may be more critical. Possibility of prejudice resulting from the stay. So these are 4 considerations to think about when either asking for a stay or responding to a request for a stay. Here's a case for California Trout Incorporated versus the United States Bureau of Reclamation. A stay of proceedings is appropriate when it will serve the interest of judicial economy by allowing for development of factual and legal issues. So for the development of factual and legal issues, it will serve the interest of judicial economy. And when weighing the hardships, favors the granting of a stay. So this is pretty hopeful sounding there, 2015 from California. District Court there in California. Then we have pendency of other action, Section 68. To obtain a stay of a later action, as a general rule, it is necessary that the 2 suits involve the same claims, subject matter, issues, and relief. Then we come to what's called the first filed rule. The first suit filed has priority over the second. There is an exception, though, the balance of convenience in favor of the second action. The second action should be stayed when rights cannot be properly determined until the first action is settled. So we have the federal court discretion. They have broad discretion to stay pending outcome of another federal proceeding. They may defer or obey proceedings where another suit with identical issues is pending in federal or state court. There are considerations of comity may indicate stay is appropriate for actions in different federal districts. And the comity here is meaning that there's an acknowledgement of the other jurisdictions, and the consideration of that may indicate the stay is appropriate for the actions in different federal districts. And this, of course, that's a mutual acknowledgement there. Should stay proceedings or dismiss claim when action involves compulsory counterclaim in another federal suit. So that's another time with the federal discretion. They should stay the proceedings or dismiss a claim when the action involves a compulsory counterclaim in another federal suit. So again, you can see why that would work, as there's a counterclaim, compulsory counterclaim in another federal suit. So there we go. Or to dismiss, depending on what this other federal suit involves. Gets pretty complicated there. Let's continue with the Section 68, the federal court considerations. They consider comity between federal courts and state courts, so that mutual acknowledgement between these courts. Evaluate common parties and issues between the actions. They assess whether the claim should be a compulsory counterclaim in another federal suit. So they're checking how that pendency of the other action. Pendency meaning it's a ongoing litigation here. It's pending, and acts as whether the claim should be a compulsory counterclaim in another federal suit, and consider actions in different federal districts. Here's our practice tip, though. The stay or continuance of a civil trial is not required pending appeal from a conviction and sentence in a criminal case merely because of possibility exists that the criminal case could be reversed and remanded for retrial. So as we see here, that if a criminal case is on appeal, the civil case does not require being stayed just because that criminal case is up for appeal. If it's already been convicted and sentenced, it's considered final, and therefore the civil trial could commence without the stay, even if there's a possibility that the criminal case could be reversed in the appeal review and remanded for retrial. It still wouldn't stay that civil trial from proceeding. That's an interesting one right there. But that's our practice tip. And let's go on to civil defendant protection. Trial courts can resume proceedings if foreign forum proves unsuitable. So if it seems like that other forum is not suitable, then the trial court can resume proceedings or lift a stay. The stay protects from difficult choice between Fifth Amendment privilege and civil versus criminal proceedings. So Fifth Amendment privileges. Let's look at this more closely here. A stay of civil proceedings can protect a civil defendant who is also the subject of a criminal prosecution from facing the difficult choice between being prejudiced in civil litigation or criminal litigation. So, these are the Fifth Amendment considerations. There's 5 factors that courts consider. 1, the extent to which the defendant's Fifth Amendment rights are implicated. 2, the plaintiff's interest in proceeding expeditiously and potential prejudice from delay. So if there's ongoing harm or something of that nature. 3, judicial efficiency. 4, interest of non-parties. As we'll see, that's quite important too. And 5, public interest in the pending civil and criminal litigation. So those are the 5 factors that the courts consider. Important to know these 5 here. So again, it says pendency of a criminal action here or a civil action, whichever way it goes, the extent to which the defendant's Fifth Amendment rights are implicated, the plaintiff's interest in proceeding expeditiously, because of the potential prejudice from delay. So there's prejudice to the plaintiff from the delay. Judicial efficiency, is it going to slow down something unnecessarily? What about interests of non-parties? And the public interest in the pending civil and criminal litigation. So those are the considerations for or against the stay. Fifth Amendment considerations. The possibility that a defendant's interest in not incriminating themselves might preclude them from testifying in their own defense in a criminal case while an appeal is pending is not grounds to refuse to lift a stay of a civil matter after plaintiffs agree not to call the defendant to testify. Wow, okay, so he didn't have to testify. It's not ground to lift the stay. The risk that the defendant might lose a civil suit if they elect to not testify does not compel testimony in violation of the Fifth Amendment. So as you see here, that could be a pretty tricky one there. If they testify in one case, then it could prejudice them against in the other case, and vice versa. So this is where the stay, the factor that the court will consider in issuing the stay in that kind of a situation. So let's see how that really happens when the rubber hits the road here. In Ray Alpha Media Resort investment cases, a stay of investors' coordinated civil fraud action stemming from alleged international investment scheme pending resolution of parallel criminal proceedings would not best serve justice in the aggregate. So the stay would not best serve justice in the aggregate, despite contention that Grant of stay would protect owners' Fifth Amendment privileges against self-incrimination. Interests of investors and the court weighed against the stay based on delay in resolving the case. Owner's guilty plea in parallel criminal case minimized burden on owner from allowing civil matters to go forward by diminishing the likelihood that any testimony he might offer might further incriminate him in criminal proceedings. An owner had the ability to object on Fifth Amendment grounds to any particular question or line of questioning in civil proceeding, at which time court would issue a ruling. So you can see the little bind there. Hammonds versus Gray Transportation. By the way, that was in 1st District, 2019. And that's looking at the Fifth Amendment of the U.S. Constitution. And it's from the California Appellate Court, 5th first, and then California Reporter. There we go, 1st District. And Hammonds versus Gray Transportation. This is out of the Middle District of Georgia, 2019 also. District Court would deny motion to stay wrongful death action pending resolution of parallel criminal proceeding against commercial truck driver who struck and killed motorists. Parties' interest in quickly resolving the dispute and court's interest in judicial efficiency outweighed any prejudice which might result from lack of access to state investigative reports or truck drivers' invocation of Fifth Amendment privilege against self-incrimination. Wow. And then we have the Stevens versus Comenity LLC. The stay, this is in, Nevada, 2017. The stay of proceedings was appropriate in cellular telephone users class action, which he alleged that bank violated the TCPA that's a Telephone Consumer Protection Act, I think, something like that, by using automatic telephone dialing system to call his cell phone without his consent, pending decision in the District of Columbia Circuit Court of Appeals case challenging the definition of automatic telephone dialing system set forth in Federal Communication Commission's FCC omnibus order. Stay was likely to be of limited duration and would automatically lift once written decision was issued in appeal. Court of Appeals decision could potentially preclude factual discovery on class-wide basis. Delay in factual discovery would not harm plaintiff, and issues raised in appeal were like key issues in plaintiff's class action. So that's where the stay of proceedings was appropriate, waiting for the appeal court's decision. And Mays versus Kentucky Judicial Conduct Commission. If a stay of a civil proceeding is granted pending the outcome of a parallel criminal proceedings, the stay must only be entered for a certain period of time. It must not place the case in limbo for years. That's from Kentucky in 2019. So if it's granted pending the outcome, the stay must only be entered for a certain period of time. Interesting there. Almost makes it kind of like a continuance, but it is, in this situation, I guess, if it happens before the certain period of time, and the stay could be lifted perhaps if the criminal proceedings move along quickly. All right. All right, before we get on to the next case, I just want to check here into the chat and make sure we're all up to date. Please hit the like if you just come in, because I'm not sure the notifications are really getting out all that well. Nonetheless, let's proceed. So we have here the Pataki versus Brigantine Incorporated. A stay of employees' punitive class action alleging violations of the Fair Labor Standards Act, the FLSA, and California's unfair competition law, the UCL, in connection with a tip pooling policy pending decision by the Supreme Court in another suit asserting an employer misclassified. Nice, misclassified employees as exempt in violation of the FLSA and California labor laws was not appropriate, where employer made no attempt to justify a stay, other than stating that the Supreme Court's ruling in the other suit was forthcoming and a stay would prejudice employees by delaying the opt-in, noticing consent, and conditional class certification procedures for punitive FLSA class action, and the applicable 2-year statute of limitations period would continue to run, and evidence may be lost during the stay. Oh, wow. A lot of reasons there. And then we have Schwartz versus Schwartz. Inaction by wife who alleged husband transferred assets to deprive her of her right to equitable distribution in connection with divorce proceedings. Trial court providently exercises discretion in staying cause of action alleging accounting malpractice against accountants, fraudulent conveyance claims against stepdaughters, and claim for declaratory relief, pending determination in divorce proceeding regarding wife's rights, if any, in the assets allegedly transferred by husband. Oh, wow. Well, that sounds dirty. Let's proceed. We're on a pendency of other action pending in foreign state or country. The general principles here: state court action may be stayed pending outcome of action in another state or foreign country, like the Korean case we heard. It's an abuse of discretion to refuse to stay a subsequently filed state court action in favor of a previously filed action in another state with the same parties and issues. Wow, an abuse of discretion to refuse to stay a subsequently filed state court action in favor of a previously filed action in another state with the same parties and the same issues. And state court should exercise discretion to stay litigation when prior action is pending in a court capable of doing prompt and complete justice. So those are our general principles for foreign state or country. So when is dismissal permitted? Another action already pending in another state. Same parties, same subject matter, and remedies in both suits. So this prevents that double dipping. State action and earlier filed action in another state involving same parties, but not substantially same subject matter, does not entitle party to stay. So we get to that doctrine of comity. Under the doctrine of comity, a state court would usually stay its proceeding pending adjudication of first filed suit pending in another state. So we have that first filed rule again, generally, with exceptions. That always means. Then we get to section 17, the pendency of other actions. Actions pending in foreign state or country. The grant of a stay where a case is already pending in another state or a foreign country court is within the discretion of the court and is not a matter of right. So here are the key considerations. Comity between jurisdictions. Fairness to litigants. Make sure no one's getting prejudiced. Avoiding multiplicity of forums. So again, you don't need to be trying the same case in different forums. Stage of foreign litigation. Is it advanced or just in the preliminary stages? And the promotion of judicial efficiency. When an action is not stayed. An action generally will not be stayed unless foreign proceeding was commenced before the action to be stayed. So we have not just first filed, but first proceeding here when we're talking about the foreign state or country. So observation is only under exceptional circumstances may a court order a stay or dismissal of an action to avoid duplicative litigation in a foreign country. Because of course it's hard to have it totally duplicated in another country's jurisdiction. So it's only under exceptional circumstances may a court order a stay or dismissal of the action. Quite interesting. Now, I hope everyone's going to be staying to the end because we'll have a special surprise at the end. So don't go away, we're almost there. Section 70 now, stay of state action pending outcome of federal action. When a matter is first filed in federal court, general rule is that the state courts stay the later filed proceeding pending adjudication of the first suit. General rule, state courts stay later filed proceedings pending judgment in the first filed action. So back to the first filed rule. As a matter of comity and discretion, state court may stay proceedings pending outcome of a related federal litigation. Under state statutes prohibiting two actions at the same time for same cause, pendency of federal action defeats subsequent filed action. So it seems like the federal action's pendency can defeat that subsequently filed action. So here's comity in practice. Even when parties and issues in state and federal actions are not completely identical, state courts may properly stay proceedings in favor of federal litigation, especially in cases with long pendency. So, state statutes. The state statutes prohibiting two actions at the same time for the same cause can defeat a subsequently filed action against the same party. In such cases, a stay is not an option that can be exercised at the discretion of the judiciary. That's going to be a dismissal, looks like. And we have the stay of state action pending outcome of federal action. When considering whether to stay state proceedings pending outcome of federal action, courts weigh multiple factors to determine the appropriate course of action. So here are their key considerations. Importance of discouraging multiple litigation. 6 of them here. We have avoiding conflicts with courts of other jurisdictions. That's the comity issue here. We want to avoid those conflicts. Whether federal action is pending in the same state as the state court action, or is it a foreign state? Whether the plaintiff's choice to litigate in two forms was designed solely to harass the adverse party. Oh boy. So they're going to look at that. And there's additional factors too, whether the federal action was commenced prior to state action. First filed, first commenced here, though. Key. This is not just filed, this is commenced. And whether complete identity as to parties, causes of action, and remedies sought exist. Complete identity to all these parties, causes of action, and remedies. And length of pendency of federal litigation. So that's the consideration here, whether to stay. When is a stay not warranted? In absence of identity or overlapping of parties, claims, and relief sought. A stay of state action is not warranted. So overlapping of parties, claims, and relief sought. If there's an absence, a stay of state action is not warranted. All right, let's move along. Seems like notifications have been pretty thin lately. Not sure if anyone got notified. If you did, please pipe up in the chat. Maybe that'll trigger something here, because it's been pretty lonely here. Let's see here. We've got this part here. Let's move on to the next one. Oh, there it goes. Jeez. A stay of state action pending the outcome of the federal action, cumulative supplement. Here's Walker versus Cedar Fair LP. This is out of the very current Northern District of Ohio in 2021. A stay of plaintiffs' punitive class claims sounding under consumer protection statutes was not appropriate, where plaintiffs had not included their consumer protection claims in their state action. These claims had not been addressed by the state trial court and were not under review by state appellate court, and accordingly, the pending state action was not going to affect any dispositive and preclusive impact on these claims before the district court. Wow. And here's Landau versus Viridian Energy, PA LLC. This is from 2017 in the Eastern District of Pennsylvania. Equitable considerations. All right, equitable considerations. Warranted stay of consumers' punitive class action brought on behalf of Pennsylvania's consumers against electricity provider alleging violations of Pennsylvania Unfair Trade Practices and Consumer Protection Law, the UTPCPL, pending resolution of 4 similar cases brought against the provider in another district court. There was possibility of overlapping classes in consumers' action, and one of the other similar cases which purported to bring claims on behalf of a broader class of providers' customers in 13 states, including Pennsylvania, and burdens that the stay would impose on the consumer were minimal, since the stay was for a finite duration and consumer would have access to documents produced through discovery in the other cases, and therefore an opportunity to develop his case. So there's a stay in order to collect extra facts to develop the case. There's one to refer to right there, and very current. And the stay of action, back on the cumulative supplement for pending outcome of federal action. Here we have Gowan versus Heli Namad Gallery Incorporated. An action brought against art dealership and gallery by ancillary administrator for estate of original owner of painting that was taken by Nazis during occupation of Paris, seeking return of painting. The surrogate court would not issue a stay pending resolution of related action in the surrogate's court, where defendants filed petition in surrogate's court to revoke ancillary letters of probate after plaintiff commenced action. Yeah, only in New York, 2018. And we're on to the stay federal action pending outcome of state action. In a proper case, federal court may, in the exercise of its discretion, stay an action pending before it in deference to the outcome of a similar action pending in a state court. In a proper case. Here are the general principles. In duplicative federal and state declaratory judgment actions, normal principle that federal courts should adjudicate claims within their jurisdiction yields to considerations of practicality and wise judicial administration. Now that's pretty interesting there, because typically it would be the other way around. Federal courts may exercise discretion to stay proceedings pending outcome of state court action. So this is actually recent authority. Yes, indeed. More recent cases support federal courts staying actions pending outcome of similar state court actions. This represents a shift from older cases that took a contrary view. And the judicial administration of this is federal courts recognize that wise judicial administration sometimes requires deferring to state court proceedings to avoid piecemeal litigation and inconsistent judgments. Wow. So that's federal court deferring to state court. And continuing with Section 71, some of the key considerations here that look at comity between federal and state courts, the inconvenience of the federal forum, as if it's easier in a state court, whether federal or state law controls, and the desirability of avoiding piecemeal litigation. So the impact of party identity. Let's get to the additional factors here. Also to consider here is permitting a state court to decide issues of state law. That's one reason they would stay the federal case, and which court first assumed jurisdiction. There's another one, the first filed, would play into that as well. So different. Let's look at this here. The different parties may still warrant stay, and non-parties in state action may be relevant. Let's see the impact of party identity. The complete identity of parties is not required for a federal court to issue a stay, although in some cases it has been deemed relevant to a decision to deny a stay. So that makes sense. If you don't have complete identity, it makes sense for a stay. But if you want to deny the stay, then we need some identity of who's denying it for whom, right? So there we go. All right, now we're on to the best part. Get out your number 2 pencil and let's take a test here. You can answer in the chat by putting in the question number, followed by the letter of your choice. And if you're embarrassed by it later on, you can always just delete it because it's just the chat. This won't be permanent. But it's just to test your knowledge, to see how much you learned from these few sections from the AmJur actions, stay of action. So our first question, a plaintiff files a lawsuit, but the defendant dies before the case concludes. What should the court do with the case? So the case is pending. What are they going to do? Dismiss the case entirely because the defendant dies? Appoint a guardian ad litem for the deceased defendant? Stay the proceedings until a substitution is complete? Or continue without the deceased defendant? Take your pick for question 1, A, B, C, or D, and just hit that in the chat. All right, now we're on to question number 2. In a case involving both civil and criminal proceedings, which factor would courts weigh most heavily when deciding whether to stay the civil case? The defendant's Fifth Amendment rights, the public interest in the criminal case, judicial efficiency, or the plaintiff's convenience? This should be a very easy one. Anyone going to pipe up in the chat? No one wants to put in an answer. All right, let's move along. Let's go to question number 3. A tech startup is being sued in both California and Texas for the same patent infringement. The California case was filed first. What would the Texas court likely do?
Audit term says E.
You got to put a number into the question.
Audit term says 2.
Okay, so you have for question 2, let's see here. So question 2, D. Plaintiff's convenience. Case involving both civil and criminal. Which factors would court weigh most heavily when deciding to stay the civil case? So the plaintiff isn't the one in the criminal proceeding. But let's proceed anyways. We got that there. For question 3, a tech startup is being sued in both California and Texas for the same patent infringement. The California case was filed first. What would the Texas court likely do? So A, stay the Texas case due to the first filed rule. B, proceed with the Texas case due to forum non-convenience. C, transfer the case to California court. Or D, proceed with both cases simultaneously. This should be another easy one here. And let's move on to number 4. A plaintiff files a federal case that involves primarily state law issues. The same dispute is already being litigated in state court. What would a federal court likely do? Stay the federal case in deference to state court. Transfer the case to state court. C, proceed with the federal case to avoid piecemeal litigation. Or D, stay only the state law issues. All right, anyone want to take a guess at either of these questions? Number 3 should be pretty easy, because the tech startup is sued both California and Texas for the same.
Audit term says C.
For
audit term says 3.
So you think they're going to transfer the case to California court? Remember, we're talking about stays here. All right, and we're on to number 4. The plaintiff files a federal case that involves primarily state law issues. The same dispute is already being litigated in state court. What would the federal court likely do? A, stay the federal case in deference to state court. B, transfer the case to state court. C, proceed with the federal case to avoid piecemeal litigation. Or D, stay only the state law issues. This should be another easy one here, because the plaintiff files a federal case that involves primarily state law issues. The same dispute is already being litigated in the state court. So think about what they could do. They stay the federal case in deference to the state court, transfer to state court, proceed with the federal case to avoid the piecemeal litigation, or stay only the state law issues. All right, enough on that. Anyone wants to take a stab at it? Then we'll move on to the answer key. So for question number 1, the plaintiff files a lawsuit, but the defendant dies before the case concludes. The correct answer is, we'll stay the proceedings until the substitution is complete. As we learned from, I think that was section 66, that the court must preserve the rights of the deceased party while allowing the case to proceed with the proper representation. So new counsel, whatever it might take, they'll have to stay, because you can't just keep proceeding when there's the other party died. Okay, so question number 2. In a case involving both civil and criminal proceedings, as we always said, the defendant's Fifth Amendment rights is the one that supersedes the others. Self-incrimination concerns outweigh other factors when criminal proceedings are parallel. So remember, your Fifth Amendment protected rights are the most important when it comes to determining whether the civil or the criminal case is the the stay would affect. If the stay would affect your defendant's Fifth Amendment rights in a criminal case, then the stay would be more applicable to the civil case. So the self-incrimination concerns outweigh other factors when criminal proceedings are parallel. All right, so number 2 was A. And now we're on to question number 3. A tech startup is being sued both in California and Texas for the same patent infringement. Okay, remember they started it in California first. So what would happen? For the Texas court would stay. They would stay the case due to the first filed rule, it being filed in California first. So stay the Texas case due to the first filed rule. First filed rule typically requires a later court to defer to earlier action with the same issues. All right, we're on to question 4, was a plaintiff files a federal case that involves primarily state law issues. So what would the court do? Stay the federal case in deference to the state court. Again, this is something because of the state law issues is the consideration. The federal courts often defer to state courts on state law issues to promote comity and avoid piecemeal litigation. So something is a very simple word like stay, as you can see here, once it becomes, get that off the screen there, sorry. Once that becomes terminology, it has a lot of other implications. With that said, for those of you that did show up, salute to you. I hope you learned something about the stay of action and actions in general, and more detail to come from American jurisprudence. At that, salute you all, and I'll see you on the next one. Peace out.
The tribe says, get the like.